morning. My name is Dineen Wasylick, and today we're going to talk about legal mistakes marketers make and how to stay out of trouble. Let me just tell you a little bit about myself first so you know why I like giving this talk. I went to college at Cornell University, law school at Georgetown University Law Center. I'm certified as an expert in intellectual property law by the Florida Bar, which means I had to take a really hard test, and it's really just my passion is the other thing that means. Probably more importantly for this, I'm a business owner like many of you. And so over the past 5 years in particular, when I've been out on my own after 20 years of practice, I've really sort of taken to heart a lot of these lessons that I used to sort of teach on a very academic level, and now I really feel the passion of the business owner because I'm trying to do it for myself and my own business as well as working with you all. So how many of you are business owners? Okay. And even if you're not a business owner, are you doing a lot of marketing for your business? Yeah, so this is going to be perfect, and I want to keep it very interactive. So if you have questions, please raise your hand. Give me a moment to repeat the question so that it's on, so that they can hear it on the screen, and we'll go forward. And I'm going to do this sort of in a storytelling mode. We're going to talk about things that I've seen and then how to fix them. So let me start here with mistake number one. There's a couple of variants of it. I hear things like, I can use any content as I want as long as I give proper credit. Not really. Or I can use any image I find on Google Images as long as there's no watermark. No, we're going to talk about why in a minute. Or number three, I can use any images I want as long as it doesn't have a copyright notice. That's not true either. So let's talk about what is copyright law and figure out whether those images are protectable. Here's the actual statute. I know it's lots of gobbledygook, but the main thing you need to understand is that copyright subsists. That means it exists from the moment that an original work of authorship is fixed in a tangible medium of expression. What that means is the moment you take something original out of your head and put it on paper or in a photograph or on a computer, anything that someone else could read with or without the help of a machine, the copyright exists from that moment on. You don't need anything other than putting it out there that someone else could read for the copyright to exist. Okay? That means that applies to things like literary works, anything that you write from the next great novel to your most recent blog post. That includes musical works, any music that you write and put sort of down on notation. Dramatic works like plays, pictorial graphics or sculptural works are things like photographs, but also drawings, clip art that you make on a computer. All of that is protectable by copyright and protected from the moment you started. Motion pictures. That's anything from your big blockbuster motion picture to your, any little video that you make on your phone. Anything that's a fixed audiovisual work would be motion pictures. Sound recordings is a recording of a song, and architectural works. I have a little picture of the Hall of Justice there for architectural works. Anyway, so what copyright does not protect are things like ideas. Just because you have an idea or a procedure or a process to do something, systems, those things are not protected by copyright law. Discoveries. Another thing that's not on the slide is, just like a short little phrase is not going to be protected by copyright law. It's got to be more original than 2 or 3 words together. And the idea is that you don't want to give someone a monopoly on 2 phrases, 2 words together, right? It's got to be a little bit more than that to meet the threshold of originality under copyright law. So, those things are covered by things like trade secrets and patents. So now we know what a copyright is. What is infringement of a copyright? Anyone who violates the exclusive rights of the copyright owner is an infringer. So the way the law works, it says if you've copied, you are an infringer. And then there's some things like fair use that we'll talk about, but that's a defense. So the first step is you are an infringer, and the second step is you have to prove that you're not an infringer. So just know that if you've copied, because one of the exclusive rights is copying, reproducing in copies. Preparing another work or derivative work based upon the original work is an exclusive right, that if you do it, then you're an infringer. Distributing copies by sale, rental, lease, or lending. Performing publicly. Displaying publicly. Guess what? Putting something on the web is probably displaying publicly. Putting something on your social media is probably displaying publicly. Okay? So taking someone else's work and displaying it, even if you don't copy it, even if you just pull the picture from their server, but you display it on your server, that is considered public display, and that can be copyright infringement. Porting sound recordings, that you probably don't have to worry about that. So I want to make sure we understand the distinction between copyright infringement and plagiarism, because a lot of people get this confused. You know, this may be copyright infringement, but as long as I add this little source of where I'm getting this from, it's not plagiarism. Plagiarism is more like that academic kind of thing where you're giving credit for ideas and telling where you got this idea from. So plagiarism protects ideas, copyright does not protect ideas. Plagiarism, usually you can resolve it just by telling where you got the idea from. Attribution does not alone negate copyright infringement. And copyright infringement is a legal thing. You can get criminal penalties or civil penalties if the person sues you. Plagiarism is more of an academic concept. It's more of a morality concept. And so you got to make sure that you keep those separate in your head and understand that giving credit alone is not going to negate any sort of copyright infringement in your marketing. So the attribution just is not enough. Practically, what does that come down to? Google Images is not your friend. I have defended many people who have done things like done a Google image search for the picture that they want and found a picture that fits what they're trying to say and put it up on their website or in their social media. And then they get a letter from the copyright owner of that image saying, hey, guess what? You've infringed my copyright. Now you need to pay me for that. So like one of my biggest recommendations is don't do that. There are other kind of sources for photographs, like Pixabay is one that people ask me about all the time. You got to be really careful to read the fine print before you're taking anything from someplace like Pixabay or anything else that claims to give you free photographs, okay? This little fine print here is from the Pixabay terms of use, and it has things like, it says they don't have model releases. So any picture that you take from Pixabay that is of a person, even if you have the copyright right to use that, you may not have the right to use the image of that person to advertise your business. You got to be really careful, look at those things. Also, they say certain images may be subject to additional copyrights and may require the consent of third party. Basically, they're saying we don't actually know if we have the rights to any of these pictures. Don't use Pixabay. You know, wherever you use, make sure you're reading the fine print. Generally speaking, most of the free services are not very trustworthy, to be honest with you, because anyone can upload anything to those services, and there's no mechanism for clearing whether or not the person who did the uploading has the actual rights to give those things away. And the problem, as I said, is copyright is a strict liability statute. Even if you think you bought the rights for it, if you're wrong about that, you can be held liable for copyright infringement. And so, you know, and certainly, this is the one case where you actually might have what's called an innocent infringer defense, where you thought you bought a license that was correct, but even so, like, do you want that hassle? I don't think so. So make sure you're reading the fine print when you're getting images from third parties to make sure that you're doing things right, that you're not going to get yourself in trouble. All of these are sources of images that I would say you got to be really careful about. You know, some more than others, and I'm going to talk a little bit about Creative Commons licenses too in just a moment. Flickr says that they have a whole bunch of stuff out there that has Creative Commons licenses. If you're doing a search, make sure you're doing the right search and you're searching for something that is allowed for commercial use. They actually have a filter for allowed for commercial use. Again, if there is a, you know, I pulled up, oh, sorry. You have to look for commercial use allowed. And if you have commercial use allowed, then you still should make sure if it's a picture of a person, I'd be really wary about using that without getting that person's permission. I would also say, give yourself time, a definite best practice. I always message the person who put the picture up and say, hey, I know you have this up as Creative Commons, can I use this for my blog? And just to make sure, because a lot of people don't realize that they're putting it up for those with those rights listed, and I just don't want to call it. I'd rather them tell me no at the front end than come after me at the back end, right? So I just give myself the time to do that. Also, if you're using something like a Creative Commons license, you need to be sure you're actually following the Creative Commons license, okay? Because, and that usually means giving the attribution back and the link back that, that you've been asked to, that the license requires. Because under copyright law, even if you have a license, if your use is outside the scope of the license that you've agreed to, that is considered infringement. So there's actually one photographer out there who I believe is actually taking advantage of that rule and posts a whole bunch of his own photographs on one website for sale. He's setting the price for what he's selling his photos for. On another website, he posts them under a Creative Commons license, but everything in big letters says free photographs. And then in little letters it says under Creative Commons license, must give attribution, all these things. And then he sends people letters saying, you didn't buy it from me here, and you didn't give me my attribution here, you owe me X number of hundreds of dollars. So, I mean, in my view, that's predatory, but the point is, he's taking advantage of what the law actually allows, okay? So you have to be aware and not get yourself in that hole. I personally feel that, frankly, for your own business, one of the easiest ways to not have to worry about this is create your own content, right? Create your own content. Take your own pictures when you're out and about. I always keep an eye out for ideas of things that I can use for my own sort of stock photography. I have a whole bank of photos that I or my husband, we kind of work together on this, that we've taken ourselves, that we've given each other permission to use, that work really well for our business. I mean, we're lawyers, so it's easy to throw up a picture of a courthouse, right? We take our own pictures of courthouses. But also, like, there was one time I saw a dead end sign, and there was a beautiful blue sky behind it. I'm like, you know what? I'm sure I could use that for a blog post eventually. Snap the picture. Sure enough, I've now used it twice for blog posts, right? So keep your eye out for that. And then also, you know, the other thing you should know is if other people are taking pictures of you and you want to use those pictures, get permission. Even though I'm a lawyer, I'm not like making everybody sign a piece of paper every time saying, yes, I give you permission. Sometimes it's just as easy as something like this. Hey, can I use that picture on my blog today? You know, someone took a picture of me that I thought was going to be cool. Yes, he sent it to me. Sure, right there, that's my license, right? I keep a screen capture. Now I've cleared it up. I've not caused confusion with the person who took the picture, and I have some records that if something does go sour later, I say, wait a second, you know, this is why I thought I had your permission. You know, and then it's kind of joking. So if you didn't ask me, that's copyright infringement? I'm like, yeah, probably not a problem, but given what I do, I can't risk it. But frankly, given what you do, you shouldn't risk it either, right? Just get those permissions. It's pretty straightforward. It doesn't have to be overly complicated to give you some more certainty. And then I also, you know, just as good practice, said photo courtesy of, but you know, because again, you're not trying to make your sources angry, right? But I got the permission first is the point, and it just makes it a lot easier. Yeah, so there's the first photo courtesy of. So some of the things that you can do to avoid getting caught up by copyright infringement, always assume anything created after 1923 is protected by copyright. Why 1923? Because the term of copyright is a certain amount of time for individuals versus companies. 1923 right now is the cutoff. It changes every year, gets a little older. But you have to assume it's protected, even if you don't see a little circle C, even if you don't see a watermark, you have to assume if you stick to your own stuff, then you don't have to worry about this. Make sure you have good licenses for anything that you didn't create. Don't exceed the scope of your license, like I talked about before. And don't remove copyright markings. If you say, oh, I can just, you know, crop out that watermark, that's actually a separate infringement of the copyright statute. There's a special, like, do not remove content control devices from things. If you're editing out a watermark, you are opening yourself up to thousands of dollars in damages. So just don't do it. Go back to the original source. Get permission or don't use it. Another thing that's very interesting is US government works by statute are not protected by copyright law. If the federal government creates it outright, then it's not protected by copyright law. It's given to the public domain. And that kind of makes sense. Like, the idea is that we pay for the government creates stuff for us, we get to use it, right? So great sources for images are NASA. NASA has awesome pictures. The National Weather Service often, if you're, you know, I've used National Weather Service images to talk about what to do when what happens to your court deadlines when there's a hurricane. I used a picture of a hurricane from the National Weather Service. So things like that can be really good ways to find free works. Make sure it's really generated by the government and not by a contractor, because we actually have someone in this chamber who takes pictures on contract for the Federal Government Park Service. He owns the copyrights of those images still. So that's the hard part, but I can tell you for sure, NASA, National Weather Service, you're good to go. Okay, this is another big mistake people make. If I paid for it, I own it, right? Not necessarily. How many of you have a full-time photographer on staff? You are a photographer on staff. But, okay, so if you have a full-time photographer on staff, is that person like truly an employee, gets an employee paycheck, and you pay taxes on them and Medicaid? Okay, that's great. There is a big misconception, I paid the photographer this picture of me, so I own it. If they're not your employee, that's not necessarily true. Or if I paid someone to write content for me for my website or design my website, and I own the domain name, so I must own everything there. Not necessarily. I paid an advertising agency for its work, so I own it all. Not necessarily. So the problem is that the person who owns the rights is the author, which could be an individual or people working together. The author can be a work made for hire if you are an employer and your person is an employee working within the scope of their employment. So the people who are actually on my staff, anything that they write is owned by my company, right? Or it can be by agreement in certain circumstances, but it has to be in writing. Otherwise, the person who is doing the creating owns the copyright, even if you're hiring them to do it for you. So you either have to have a work made for hire agreement if you have the right kind of work that you're even creating, or you have to make sure you have a written agreement to transfer those rights from the person you're paying to you as the person who's asking for it. Basically, by conveyance or operation of law, basically if you have a contract or a will, like that's what happens a lot in like the music industry, where rights go from the original person who wrote the music to their children, their spouse and children that die. The biggest thing is that you need to have a writing signed by the owner of the rights conveyed in order to do that transfer. The law says it has to be in writing, so your verbal agreements with people saying, oh yeah, I'm going to take this and you're going to give it to me, are not enough. It has to be in writing. And by the way, a click wrap agreement can be enough. There have been cases where, like for example on a real estate website, where the terms of service said, by uploading these pictures of these photographs, you're conveying the copyright ownership rights of the photographs to the website, and that has been upheld. So again, I'm going to say, read the fine print, read the fine print, read the fine print. But you need to understand if you're uploading, whether you're transferring your rights, but also if you're getting it from someone that you're paying, whether you've gotten the proper transfer of rights. So what is a work made for hire? That's one of those phrases that people use all the time and don't understand. Again, either an employee working within the scope of their employment, someone who's actually on your staff, or specially commissioned for use as, there's all these kinds of things. Like for example, as a part of a motion picture or audiovisual work. The idea is the motion picture industry doesn't actually employ, like the one studio does not have everyone on staff. They use actors who are not employees, they're free agents, they use photographers and videographers and all these type of things. The idea is we're going to make it easy for a movie. All those thousands of people can just write something saying, we agree this is a work made for hire, and the studio owns it, and then the studio owns it, right? You don't have to have everybody an employee. Translations, you can see where that would happen a lot, where you would hire someone to do a translation of a work, and so they just made it very simple in the statute. When you do a translation, if you have a written document, then it transfers. But it's not every kind of work. Some of these are really old tests and atlases. Like this is like vestiges from 100 years ago in the statute that aren't really very relevant to what you all are doing today. And even then you have to have the writing. So the important thing is you need to assume that unless you're doing video, that your work is not a part of this, and you have to have a written assignment too. And these are kind of what the rules are to look at what an employee is. I mean, it's very detailed, but the point is, look at your tax status. Do they have benefits? Are they working in your office using your equipment, or are they working out of your office using their own equipment on their own time? I mean, most of us are small businesses. We're hiring someone else to take photographs for our headshots. We're hiring someone else to take photographs for our events. We're hiring someone else to do our web design. They're not on our employee staff. And so you have to assume it's not going to be a work made for hire. We call it a belt and suspenders agreement. Usually you should say in your agreement that we agree that this is a work made for hire, and just in case, we also agree that I hereby assign all the rights to you, or you hereby assign all the rights to me. And the idea is that then you have it either way, right? You want to make sure at the end of the day that you own what you've paid someone to give you. So best practices are have those written agreements with your independent contractors that say both work made for hire and assignment. If you're taking submissions online, have terms of service that say how those are coming to you so that there's a clear understanding. Is it an assignment? Is it a license? What are you getting when you're saying, here, submit this online to me? Understand your license terms if you get things from third parties, and keep good records of this stuff. Especially on a website, if you're adding content and adding content and adding content, it's really important to remember where you got stuff 5 years from now. If you're using a third-party web designer, for example, and he or she or they are licensing photos for you, you should get copies of those licenses as part of your sort of paid in full package. Demand that. Negotiate for that. Make sure you have that, because you're the one who's going to be holding the bag 5 years later when someone says, hey, wait a second, that's my photo, and we don't have any record of you. And you need to say, oh, yeah, you don't have record of me because my designer had this license which flows through to me. You want to have that in your hand. What if your designer is no longer in business that 5 years from now and you don't have those records? So keep the records. I mean, just have a folder on your computer where you drop all this stuff. Make it as easy for yourself as possible, but just have it as well as you can in one place so that you can defend yourself if you have to. Here's another one. If I own it or I bought it or paid for it, I can use it however I want. Again, not necessarily. And the reason is what I alluded to before, the idea of model releases, right? In addition to copyright law, there's also right of privacy law that protects an individual's rights to have their image used for advertising purposes only with their own permission, okay? So you can't use someone else's image for advertising purposes even if you own the copyright in the photo. Just because I took the photo of you doesn't mean I can use that photo of you for advertising images, for advertising purposes. You should get a model release from people if you want to use their stuff in advertising. And obviously, there's sort of a continuum. You can have an oral agreement. Of course, oral agreements are harder to prove in court than written agreements. So maybe you can feel comfortable relying on an oral agreement for a social media post, although why not confirm it in text so you have something, right? But if you're going to be doing a billboard campaign where someone's face is literally going to be, 5 feet tall on the interstate, make sure you have that person's, express permission to use their image. If it's you and your employees and you have their express permission, that's great. But if you're buying stock photography for that purpose, you need to make sure that that stock photography includes a model release. There have been cases on things like, even when a model has signed a release, if the release is not express enough, yes, I posed for those pictures because I wanted to, I wanted to make money as a model, but I did not give permission for you to imply that I have AIDS, for example, right? Or imply that I have some other disease, or imply that I have, or I believe something I don't believe. Don't put someone, yes?
So you're saying if I come and take a picture of everyone together,
right,
I can use that for social media, but I can't use it for other things?
So I would say that anything that's very express advertising, like purposeful advertising, like, here, look at all these happy people, buy my product like them. That would be, even on social media, that would not fly, right? Here's a bunch of people I went networking with, probably okay, right? Because it's not like I am advertising a particular product in this moment, even if it's on your business website. But sort of the level of sort of from social media, and also we have sort of an 80-20 rule going on here, right? I think people nowadays kind of expect that their images are going to be on social media when they come to this kind of event, right? And so you're not going to, even if perhaps it might technically be a violation of the statute, it's very rare that someone's going to complain. And if they do, the easiest thing is you can take down the post and they're probably okay. But as you're going on that continuum from, here we were networking, to here's a satisfied client if they haven't agreed, that's not good, to here's a mailing flyer campaign with your picture going to 10,000 people, or a brochure with your picture going to 500 people, or a billboard or a newspaper, like all those, the more true advertising it is, the more you need to be sure you have that model release. Because the idea is, people have a right to choose what they're endorsing, right? And so use sort of an endorsement rule in your head. Or is this person endorsing my business by being in this photo? If not, a crowd shot usually is not considered to be an endorsement, even if it's used in an advertisement. There was a famous case of a crowd shot of people at a baseball stadium, and the guy who was in the picture was supposed to be at work and got fired because of it. And the court said, crowd shot, sorry you have to be in the crowd, but that's not a violation of this, this right of privacy. You're in a crowd. So, so there's definitely a continuum. But again, if you're going to invest to print a whole bunch of things, make sure you're investing in something that you're not going to have to throw out. Is really, or invest to print in a billboard. Make sure you have that model release. And a lot of correct, paid stock photography services will say there's a model release. Like one of the ones that I've seen people use effectively is Adobe has some stock photography available. And it says on there, if it's an image, whether there's a model release included in it. Make sure you have that before you use pictures of people, okay? Another trap that people fall into a lot is if they have like a bar or a restaurant or some other sort of storefront, and you're playing music or you have TVs on, that's really ubiquitous, right? If you don't have the proper licensing for that, above and beyond sort of the normal just put on a TV and play it, you can be sued for that. It's a violation of the public performance right of the people who create that music. So another one is incorporating music into videos without permission from the music owners. Like a lot of people say, oh, I just want to have a good background on my video. This is cool. I found something great, or a popular song, right? YouTube probably has the technology to flag that if you put it on YouTube at this point. But even if you don't get flagged, you can get caught. So be careful on that. Some of the sort of at-home movie making include with them licensed, royalty-free licensed music tracks that are clear. And they say that they've been cleared. Without that, you got to be careful, because music in a video is going to get you in trouble. Pretty much anything, there's companies like ASCAP and CSAC and BMI and the Recording Industry Association, and all they do is work on behalf of singers and songwriters and record companies, and just like go out, and the Motion Picture Association for videos, and go out and find people who infringe. I have a client right now who was sued by BMI for playing music in their bar without having a proper public performance license. So again, even with your TV, if you're like getting TVs in your business or something like that, ask the person who's installing for you, I need a business license, not a personal home license for this. It's going to cost you more than someone's home cable because it's making those licenses back, but it's going to cost you a lot less than a lawsuit. Okay? There are some like really minor exceptions in there for certain small enough TVs and stuff like that, but what people do now usually outstrips what the exceptions are in the statute. So I would just say make sure you've really studied those exceptions before you rely on them or talk to a lawyer about them. I'm going to talk about fair use a little bit. A lot of people think, oh, if it's just funny, it's fair use. If I only use a little, it's fair use. I always kind of say, you keep using that word. I do not think it means what you think it means. Just like Inigo Montoya in The Princess Bride, right? So let's talk about the funny part first and what parody really is. For the purposes of copyright law, parody has to be quoting the existing work and have a commentary on the author's work. And so just because it's funny doesn't mean it's parody. It actually has to be like social commentary as well. This Campbell v. Acuff Rose case from 1994 was one of Ruth Bader Ginsburg's first opinions from the Supreme Court, and they were considering whether Two Live Crew's song Nappy-Headed Woman was a parody of Roy Orbison's Pretty Woman. And the the lyrics of the rap song start out very much mirroring, and then it goes on and gets nastier and nastier, frankly. And the deep analysis turned out that that was social commentary, so they considered it parody, and it was not copyright infringement, but that had to go all the way up to the Supreme Court to figure out. So just make sure you know that it has to be commentary. I always think of Weird Al when I think of this, because people are like, oh, Weird Al's so funny. Just changing the lyrics alone is not enough. And some of his songs could be considered social commentary on the original, some of them not so much. He always gets permission from the original authors before he goes out and markets something, and he negotiates a royalty back to the original folks, because he doesn't want to get in that, he doesn't want to rely on fair use. Relying on fair use can be pretty tricky. Also, parody and fair use are an avoidance to copyright infringement. Remember I said, the statute says if you copy, you are an infringer. Anyone who copyrights any of these exclusive rights is an infringer. So that's the default rule, and then it's on you to prove that it's not infringement because it's fair use. And so understand that if someone wants to come after you, they can, and then you have to show the other way. So is this a parody? Anyone? Just having this meme from the area, people think, oh, memes are funny. Is that a parody?
Who is it, by the way?
Inigo Montoya from The Princess Bride. And he said, this is an exact quote from the movie. So an exact quote from the movie, not a parody, right? It's not making fun of the original, it's showing the original. Okay, so the next question is it still fair use? Even if it's not a parody, it might be fair use. But you have to do like this big analysis, right? And there's these 4 factors that fair use looks at. The purpose and character of the use. Are you using it for commercial purpose or for educational purposes? The nature of the copyrighted work, the more creative it is, like a painting or a movie, the more protected it is. The less creative it is, something that's something close to the phone book, is not going to be, it's going to be considered a thin copyright and not as protected. The amount that you use, are you using a lot or are you using a little? Probably most importantly, the effect of your use on the market. A good rule of thumb to think about is if you could purchase a license, then your use is undermining the market and is probably not going to be considered fair use. So if there is a market to purchase licenses for the kind of use that you're planning on using and you don't follow that, it's going to weigh against you, okay? So that leads to the myths. There's a magic formula percentage that I can come up with before it becomes copyright infringement. Not necessarily. I have seen cases where someone copied 100% and it was still considered fair use. I have seen cases where someone copied 10% and it was not considered fair use. The percentage isn't enough. Certainly, the less you use, the more that weighs in your favor, but it's not determinative. There's no magic number that, if I just use 10%, I'm good. As long as it's breaking news, it's fair use. Again, not necessarily. There have been a lot of cases lately where people have been sued for using a photo that some bystander took and then the newspaper is using it. You'll see a lot on social media, by the way, if someone posts a video that is newsworthy, a lot of times someone from the local TV station, whatever, will say, hey, this is so-and-so from ABC Action News. Can I use that video and give you credit? And the person says, yeah, sure. They've just gotten their license, right? They're just trying to avoid having them come after them later, because there have been cases where people have come after them later for using a video or a photograph that was taken even though it was kind of a hot news thing. As long as I give attribution or a link back, it's fair use. Again, we've talked about that. That's not going to be enough. As long as I don't charge for it, it's fair use. Again, whether or not you charge for it is not going to be definitive. Not charging helps, but if you're still getting a financial benefit from your use, that's probably going to weigh against you. So all of those are not easy answers. Let's come back to this. My use of this one image and this quote, is that fair use? What do you think?
Yes.
Why, Scott? You think it is fair use, why? Okay, so I'm going to argue that it is because I'm using one still image out of a 2-hour movie. So I'm using like a very infinitesimal amount, along with one quote, an infinitesimal amount. And I'm using it for educational purposes, right? I'm trying to teach you guys. And I don't think I'd get a license for this one meme. I don't think I'm undermining any market for a still image from this movie. So I'm probably okay. And again, I'm also operating on the 80-20 rule. I'm just assuming that that no one's going to be seeing this and suing me for copyright infringement for this thing. So probably, but you have to think it through every time, right? I'm just going to take the risk in this case because I don't think that they're going to sue me for it, frankly. But it is every time you're making that decision, you are taking a risk. So best practices, don't copy anything in whole. Link back to original content instead of putting it in your website. There was a whole stream of cases where people were just like pulling entire blog posts into their blog posts. Don't do that. Give your own commentary, link back to someone else. Yes, maybe it's not giving you quite as much SEO, but it's better for you to have your original content and have a link back as far as fair use is concerned. If you are doing commentary, take only enough to facilitate your commentary. Usually a couple sentences from a news story that you link back to, but then you have a lot of your own commentary with it. That's going to be fair use, right? Provide attribution. Look, I know I just told you like 10 times that attribution is not enough and does not negate copyright infringement. But if you're doing all these other things and you're sending people back and you're saying where you're getting it from, that will sort of look good to a court. It shows you're not trying to steal, right? And don't undermine the markets is the big one. If you can go out and buy a license for that particular photograph, don't use it without a license because you're going to get yourself in trouble. When in doubt, get permission or talk to an IP attorney, frankly, right? Because I've been doing this for 20 years and I still can't tell you 100% that I'm going to be right about whether something's fair use, but I can kind of tell you I know it when I see it just because I've read hundreds and hundreds of cases where courts have done this analysis and can synthesize all that. It's really hard to do that just sort of navigating your own life if you've not studied it that hard. I'm going to talk a little about trademark law too, because this is another one that I deal with a lot. People think, oh, if I can get a name on Sunbiz. Yeah, did you have a question? Oh, sorry.
Yeah, yes, I did.
Okay.
I'm going to be doing a PowerPoint
Uh-huh.
on labor law.
Okay.
And what I was thinking about doing as an intro was the theme song from Star Wars.
Right.
And then, as it fades out, a picture of Morgan and Morgan.
Okay.
I think it's funny as heck.
So there's a lot to unpack there, though. So doing a PowerPoint with something from a movie and something from an image of someone else who is not you and your law firm.
Well, again, I'm not an attorney.
Right.
I have a payroll company.
Right. So doing all those things, there's a lot of the fair use kind of things in there. Is it social commentary? Not sure. Is the amount substantiality being used little enough that it would be considered fair use? Maybe. The answer is it depends, and also who you're giving this to and why will also go into that.
Well, it would be like a
Yeah.
like this or at a Rotary.
Right.
Something along those lines.
Sure. Well, again, and also you have that sort of 80-20 rule where will you get caught? 80% says no, 20% says yes. The bigger your audience, the more you're going out there. If you're videoing it versus not videoing it, if you're posting it online versus not posting it online, the more likely you're going to get the attention of someone else when you're doing that kind of thing. So I try really, really hard when I'm doing this kind of thing. Like, I don't know if you saw before, but I had the belt and suspenders picture. It was from Flickr. I gave the full Creative Commons license of it, right? With the Weird Al, I gave the full Creative Commons license from that. Because I know, especially as a copyright lawyer, that people are going to say, you know better, right? So you have to ultimately come up to your own risk tolerance level to decide whether or not you think that that is fair use based upon the factors, and whether you think that you're going to get caught, frankly. It's expensive to bring a copyright infringement lawsuit, and so most of the time, they're not going to do it unless they think there's a lot of damages. But there is one thing that I want to make sure I mention right now, actually, it's important. I told you in the beginning, you don't have to have a registration to own the copyright, right? The copyright subsists from the moment that you create it. However, if you do have that registration prior to infringement, then you have two really big benefits that big companies use against the little guys all the time. Those are the right to collect your attorney's fees if you have to sue for infringement, which is huge because we're expensive. And then two, also the access to something called statutory damages. The idea is instead of having to prove your damages, you can just say, you know what, I'm going to elect statutory damages and let the court decide some fair number, somewhere between $750 and $150,000. That's a big hammer. Not everybody gets $150,000, right? But the fact that you can be liable for up to $150,000 for infringing a registered copyright, that gives you pause, right? That's the whole thing that you see in the front of a movie when it says FBI warning, you could be criminally liable or liable to fines up to $150,000. That's what they're talking about. The idea is that the law has kind of said, well, sometimes, you know, it's hard to prove the damages, but if you take the time to say this is important enough to me that I'm going to register it prior to putting it out there, we're going to give you an out to get damages whether or not you can prove your damages. The damages are normally the profits of the infringer attributable to the infringement, so what you made by your infringement. Also, the lost profits of the person who owned the copyright. So if they normally would license that clip for $100, maybe that's the damages. Maybe it's not worth suing you for that. But because they have the registration, and I promise you they have the registration, they can threaten you with up to $150,000 in attorney's fees. So that is what you're facing when you're taking something from.
So you're telling me I shouldn't pull a picture of Morgan & Morgan?
Well, then you're also dealing with his rights to publicity too, aren't you? If you're using his actual Morgan's image, right? Because you're using him to advertise your business potentially. So I just say be cautious. So talk trademark a little bit because this happens a lot. People say, oh, my company name is available on Sunbiz, so now I own the rights for that for everything. Or it's not infringing someone else's. Or now I've registered my business name, so now I have a trademark. Neither of those are true. Okay? I'm going to tell you a little bit about what trademark is and is not, and that'll sort of make it clear. Trademark basically acts as a source identifier. The idea is that you see something and you know I'm going to get a certain quality of goods or services, right? Connected with a single producer in the mind of the public. It can be just text, it could be a design, it could be a combination. You know, we have, like Starbucks is a great example. They have plain text, they have it in a special font, they have it without any words at all, they have it with the word Starbucks. All of those, you see those, you know you're getting a certain quality of coffee whether you're in Florida or California. Now, we could argue whether you like that quality of coffee, that's fine, but you're going to get the same thing whether you're, you know, wherever you are in the country, right? That's the source identification function of a trademark. And the reason we do that is a consumer protection kind of thing. The idea is that we're protecting consumers, that they know if they're buying something that has this phrase or picture or word on it, they're getting the same thing wherever they go. And so when you look at it that way, you want to make sure, let me go back for a second, you just want to make sure that you're not confusing the public. If you want to go out and call your coffee company Starbuds Coffee, well, it's not the same word, but it might be close enough and it's the same products that it's causing confusion. But it's really important to understand that the test is not just, are the words the same? The test is confusion. If it was just, are the words the same, then Delta Airlines and Delta Faucets couldn't be sort of out in the marketplace, both doing their thing without any confusion. Now, I will tell you, they did that for decades without a problem. When the internet came along, they had a little kerfuffle, right? They fought over who got to own Delta.com at first, and finally sort of worked that out, because the problem was they both had trademark rights for very different goods and services, but you know, clearly when people go to the internet, they might have just typed the trademark sometimes. So even when there's harmony, sometimes online makes it harder, right? So you have to do more than just, is it the same? Yes?
We had a debate the other day about the difference between TM and R. What's the difference between trademark and registered?
Absolutely, it's a great question. So TM is just saying, I claim this as my trademark. And you may do that whether or not you have a registration. Like copyright, trademark right, well, copyright, it's obsessed from the moment you write it down. Trademark rights come from usage. The more you use something as your trademark, the stronger your trademark rights get, okay? And doing that little TM on there tells the world, hey, this is my trademark. I'm using this as my trademark. And you don't have to have a registration to do that. And it's advisable because you're giving notice to the world. If you ever are in litigation, having that TM there and then having someone see that and copy it gives you better remedies, because now it's willful, because they know that you have claimed it as a trademark. The circle R stands for registered trademark. So there is a process with the United States Patent and Trademark Office to apply for and obtain a registration of your trademark. It is not required to have trademark rights. It does make enforcement easier to be able to waive around that registration certificate. It also gives you some benefits after 5 years. You might have an incontestable mark. It makes it easier to prove your trademark rights in court. You can only use that Circle R if you have a federal trademark registration. If you do not have a federal trademark registration, use that Circle R, you can actually be fined for doing so because you're confusing consumers, right? All about protecting consumers. So great question. When you're picking a trademark or you're picking a name, I always tell people to be really careful about it. There's kind of a continuum. If you go from generic over to fanciful, the generic name, you can't get a trademark for bread if your product is bread, right? The idea is you don't get to get a monopoly on the name of the product just because you're selling it, right? So trademark law is trying to balance sort of free speech with this source identifying function. So, you know, just apple for apples is not going to be a trademark. You have to have something more than that. So the next stage up is something that is merely descriptive. And that's not the greatest trademark, but that's where a lot of people like to go because they want to tell people what their business is, right? So something like Children's Place for children's clothing. The trademark office said that's really descriptive and that does not qualify for a trademark unless you have what's called acquired distinctiveness. You basically have to prove that even though it was descriptive, you've overcome that and you've now made a brand where people associate that phrase with you and you alone, okay? That's work to do. Sometimes you can do it after proving 5 years of continuing use and just claiming that. Sometimes not. If it's too descriptive, forget about it. But if it's, you know, something like Children's Place or Best Foods, they were able to show we put marketing dollars behind this brand, people associate this with us. You have to prove that consumers associate that otherwise descriptive name with you and you alone in order to have a trademark. So that's pretty weak still. Once you get to the suggestive column there, now you're starting to be in a place where it's a little bit easier to get a registered trademark. It indicates the quality of the goods without telling you exactly what they are. Things like Greyhound for bus services. The idea is that it suggests that you're going to move quickly through the world, but you know, a dog is not a bus. So it's, you know, it's suggestive. Microsoft, it suggests like that there's small software or whatever, but you know, but it's not, you know, that's suggestive. So that you can get a registered trademark for pretty close. It can be sometimes hard to draw the line between what the trademark office is going to consider descriptive versus suggestive. I've been surprised sometimes when I'm doing research for clients to find that something that I thought was suggestive, the trademark office has already found to be descriptive, so it's tough. The dark green column, that arbitrary column, that's your strongest trademark because you're using an existing word, but you're using it in an entirely arbitrary way. Apple for computers. Like you never would have associated an Apple with a computer before Apple Computers, you know, came up with that, named their product that, and created wonderful marketing around that, and created that association. And now there's no way anyone else could ever call them, any other computer company could call themselves Apple Computers without causing confusion in the marketplace, right? It's because it's arbitrary, it's very strong. Amazon for books. Before Amazon.com came along, Amazon was just a river, right? But now it's also, you know, or a jungle. Now it's an online seller that has a very strong name. The last category is like a fanciful or coined or made up word. Kodak was a made up word applied to cameras. Xerox was a made up word applied to copiers. The only problem with fanciful terms is if you're too good. If you're like the market leader, you can end yourself up down in Genericville because people just like start associating you with the product. Kleenex for tissues. Kleenex fights that all the time. Velcro for hook and loop fasteners is one. They fight genericide so hard, they come to trademark lawyer conferences and give out free Velcro and have all these signs about why Velcro is not generic, and they do all of that so that when their trademark registration comes up the next time, they can prove to the trademark office, look at all the things we have done to prevent this from becoming a generic process. I don't know, did anybody see the video that they put out about a year ago where they had a bunch of lawyers singing about hook and loop fasteners and why, you know, Velcro is not generic? It was pretty definitely for a lawyer office audience, but it's also very funny. But the idea is, you have to fight against that genericide if you're almost too good for your made-up name. If they didn't have a made-up name, they might be better off. So, see, aspirin, for example, is a really good example of that. Aspirin was originally a registered trademark of the Bayer company for that type of medicine, but over time it just became the generic term for acetylsalicylic acid, right? So pick arbitrary, if you're picking names, that's probably the best thing. Because otherwise, if you're causing confusion or deceiving as to affiliation or making it look like the trademark owner is sponsoring you or approving your goods, that's going to be considered the trademark infringement. You get the trademark rights from usage, right? The registration is not required, but you do get benefits from it. It doesn't have to be exact to be infringing. We talked about Delta Airlines, Delta Faucets. When you register a business name in SunBiz, they're not doing any of this that I'm telling you that you have to do for trademark purposes. They're just looking and saying, do we have these exact letters in this exact order registered or not? If not, they'll let you take the business name. But if someone else has almost the same, maybe add an S or take away an S, things like that, they may have trademark rights if they're doing the same thing that you're doing, and you may be infringing them if you're registering that name. So I encourage you to do searches on this. Your best practices are to do a trademark search before you pick a business name. Use your trademarks as adjectives, not nouns or verbs. Your trademark is not, the product is not Starbucks. The product is Starbucks brand coffee, right? You got to use it to describe it. And that, you see this a lot when businesses do press releases. They're very careful to say, our Xerox brand copiers are blah, 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 not just our Xerox machines, right? You have to use it, your trademark is making it your brand and not just the thing itself. Kleenex brand tissues, not Kleenex. Performing a search on Google, not I Googled it. Google is fighting that one hard. Use the TM symbol like we talked about already with your trademark. And consider getting registration. As I said, there are some benefits to that. I always tell people, obviously if you're starting a business, do the search in the beginning. Once you're in business, obviously that ship has sailed. Still important if you want to try and move forward or expand, do that search. Find out what else is out there, and find out before you apply for a registration whether or not we think we're going to get a registration. There are a lot of folks where they come to me and they've been in business for 10 years and they say, hey, I want to register this trademark. I'm like, great, we need to do a search. And like, no, I've been in business for 10 years. Like, we still need to do a search. And you find out that there's something out there registered that I think is going to block the registration. And we can talk about what to do about that if that's your case, whether you consider changing your name or flying under the radar. There's a lot of options depending on risk tolerance. But at that point, before you apply for registration, you should know what's going on out there. Florida also does state trademarks. They don't have as many benefits as federal trademarks, but they can protect you in Florida, and they can give you access to attorney's fees if you have to sue. So that can be an option for some folks who have a more local business than getting a federal registration, and I'm happy to help people figure that out too. There's a lot of other mistakes that businesses made generally that I'm just going to throw out there. Don't give away your trade secrets. Don't tell stuff, your ideas that you're a secret without a non-disclosure, for example. Patents, I don't get into it all on this because it doesn't happen a lot in marketing, but just know a lot of times if you're inventing things or if you think you have an idea that should be created, it might well be a patentable thing, not a copyrighted trademark thing, just to be aware of. If you have a website where people are posting content on your website, where you're inviting people to do commentary or you're hosting people doing commentary, you need to have a registration with the Copyright Office to protect yourself if what they post on your website ends up being infringing. If you don't have that, you can be personally liable even though they posted it. So that's another important thing a lot of businesses run into. I see so many people removing those copyright protection markings, as I mentioned earlier. Don't crop out a watermark, whatever you do. If it's there for a reason. Go track down the original source or find something else. Don't let your web person register your domain name. The web host small business scenario I come into a lot. Make sure the domain name is in your name, that you control the registration of the domain name, that you have writings with your web people that you own what they create for you. Otherwise, you could be held hostage if you ever have a situation where coming to a disagreement. I've had many businesses come to me with, they won't let me access my website. What do I do now? So you got to be really careful about who you give the keys to the castle to when it comes to your website and your business. I can go on and on and on and on, but I would like to answer any questions that you guys have about any of this. I know I've thrown a lot of tough stuff at you, but I really wanted to make sure that you understand kind of the underlying rules, so you understand why I'm telling you to do what I'm telling you to do, and not just like have no context. So, any questions?
What's the statute of limitations? What's the statute of limitations for somebody taking your work?
So that's a very interesting question, because the Copyright Act has a 3-year statute of limitations. From the time that someone infringes, you must sue within 3 years, so you've given up the damages for that particular infringement. However, there was a Supreme Court case about 2 years ago that basically said, even if the statute of limitations has passed for the first infringement, if someone's continuing to infringe, you can go back for 3 years worth of damages. We called the Raging Bull case. It was the daughter of the person who wrote the script for Raging Bull, who sort of inherited the rights later, sued and went all the way to the US Supreme Court and said, I want my damages for the last 3 years for all these copies of Raging Bull. And they had originally told her no. The lower courts had said, nope, you can't get it. You know, you've known about this for 30 years and you're just coming to us now. You can't do it. You're barred from bringing your suit. And the Supreme Court said, you know what? We're not going to do that to copyright owners. There could be reasons why it didn't make sense to sue 30 years ago, but it does make sense to sue now. We're going to limit you to 3 years, but we're not going to stop you from that. With trademark, it can be 3 to 4 years, kind of depending on the context. It's not as statutorily clear, but the reality is, again, if you have sort of ongoing violation, you're probably going to have ongoing damages. And so, even if you find out about this now, you don't want to sit on your rights too long, especially in trademark world. But statute of limitations in the IP world are not as helpful or hurtful as they are in sort of other areas of law. So, any other questions? Yes, Scott. Hold on, wait for the mic.
So Saturday evening, famous speaker was at an event. I took about a 6-minute video as part of the presentation. Asked the person afterwards if I could have a business card, wanted to get everything in writing to see if I could use a short 5-minute segment of the video on a website. It's a nonprofit website that I run. And he said, you're just using it on this, it's not profit, yes, you could use it. So I got the verbal there in front of a bunch of people, but I know it's better to have that in writing.
Right. So, you have verbal and you have witnesses. So, I mean, I just always think about it as what's going to happen if I have to defend myself in a lawsuit about this. So, in a verbal, you really got a he said, right? Although you may have some witnesses who have said that. I try very hard to do the follow-up. Hey, here's the email just confirming that on blah, 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 you told me blah, 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 blah. Even if they don't respond at that point, you've confirmed it contemporaneously at the time, not 5 years later when they're accusing you of infringement. And if he doesn't respond to that, that's a pretty good indication that is a good summary of the discussion that you had. So that's what I would do at the very least if you don't have it in writing. Other things you consider doing, hey, can I just film you saying that real quick so I have it, You got to kind of gauge the whatever. Get a film, yes, yes, you can do that. The email, that's my text message example that I did earlier. Those kinds of things, the more physical objects versus verbal recollection that you can rely on, the stronger you are. And then again, of course, there's always that 80-20 rule. You're probably okay, but I would at least think about sending that confirmation email. Again, if you get something back that's different than what he said, better to know now, right? So that's kind of a way to approach it. Try to take a practical approach, but a practical approach that protects you as much as possible. Any other questions? Yes, sir.
So I'm doing a community video for, say, Connerton. A family biking towards me from the distance.
Right.
Is that something that I need?
Yeah, so I would recommend that you get a model release from them. Most people are like, you want to put me in the video about my community? That's awesome, sure. Yeah, so that would be what I would do. A family biking at a distance, if you can see, if you think that someone who doesn't know them, who knows them would recognize them, then probably.
So if they're biking away from me,
If they're biking away from you, you see the back of the head. That's one good way to get around things. So see the back of their head. You're not, they're not showing their face to endorse things. That's probably going to be okay.
how
Yeah.
about the Publix? A shot of the Publix in the video, is that infringing on Publix?
So that would be more of a trademark issue than a copyright issue, right? And there's a concept in trademark law called nominative fair use. Just means you're using something to name something. The idea is I'm showing an image of the Publix because I'm letting people know that this is where a Publix is, right? Not because I'm trying to confuse people about grocery shopping. I'm trying to say, hey, that's the directions to this place, go use their product. So that's probably going to be okay if the purpose is to show, so your amenities in your community. I'm sure Publix, and again, with the 80-20 rule, I'm sure Publix is glad that you're telling people, hey, come to Connerton, there's a Publix right here. So they're probably not going to say, wait, you're using our trademark for advertising purposes, because they want to be associated with that community or they wouldn't have built there, right? So if you're using it nominatively, the test for nominatively is, if you're just saying there's a Publix, you just, write the word Publix, don't use their logo, for example, if you can. If you're taking a picture of the building, you can't really not use the logo, but you don't have to have the picture of the building, in the entire video. You're supposed to use only as much as you need to convey that information. A couple second shot, just saying we have a Publix, is probably going to be okay. That's kind of the analysis that we would go down to do to clear that kind of thing. Any other questions? Yes.
I know we have a few members that are like in direct sales, so they're 1099 under a parent company. When they use content that maybe someone submitted to the company, like a photo, before and after that they submitted to the company,
right?
Because the companies had permission, does that give the person that sells the products permission? Or
So that is going to depend a lot on what the agreement between the independent contractor and the parent company is. So it is very likely that agreement covers those kinds of things. And then you're just relying on the parent company to have gotten the proper model releases and permission. I mean, again, in those kinds of situations, people are like, hey, here's my before and after. I'm so proud of myself. They're okay with it. They've submitted those pictures, right? They've gotten some sort of permission. But that's the kind of thing where maybe I give it to you. I'm okay with you posting it, in California, but maybe not in my backyard. And so those are the kinds of things you want to make sure that you have you understand what your rights are. So I would say start by reading your own agreement with the parent company first. Yeah.
I have a quick question. If anybody is doing networking meetings or Rotary clubs, whatever, at a hotel, does hotel generally have to have a license to play music, like if they want to play their own, iPod, whatever, when people come in and stuff like that? Or
So
is it infringing on the music stuff?
Yeah, a lot of times the meeting places do provide that license and should have that license. And bringing in a DJ or playing music or those kinds of things, those are usually covered by the license that the institution has. Both BMI and ASCAP cover different sort of libraries of music, and they will, and you're best to have both of those if you have a venue where you're playing a lot of music, either by DJ or live, and they kind of break it out by how the types of ways you're playing music to. When you have live bands versus DJs, you have to have that permission. BMI, for example, is very aggressive about coming after bars for not having licenses because they're playing music on their jukebox, or there's music on the TV in the background that's not paid for, or they're having live bands, and all of those are issues. Another question, Scott?
Yes.
Okay, there we go.
So sitting down yesterday too, I'm building a website for a professional sports player, and it came up, one of the images they wanted to use on the website was one that we did find on Google. It is of them, and they're going, why can't I use the image of me on there? So do they still have to go through the same process?
Yeah, so that's the
and
same
still
flip side of the original thing, which is just because you're in the picture doesn't mean you have the right to use the picture. You have to have permission from the copyright owner too. And so, you found a great image on Google Images. Who took the picture? If it's a Joe Schmo on the street, probably just saying, hey, can we use this on their website? They're gonna be like, oh my God, the professional athlete wants to use my picture, sure. And then you have that written permission. If it's a news photograph or something like that, there are ways to license those photographs, and that's what you should do. So, yeah. Anything else? All right. Well, I'll just finish up by saying thank you all for your attention. I know the legal mumbo jumbo can be a lot of mumbo jumbo, but it's also really important to sort of make the right choices as you're navigating through and keep yourself out of trouble. It's much cheaper to figure it out on the front end than to defend it on the back end with a lawsuit. And finally, if you haven't already, give me your business card. I will share with you some sources of some public domain images that I use a lot in my marketing. Big libraries of images. You're not going to probably use the same picture that I am. Big libraries of like older photographs, older drawings, older posters, things like that that are clearly old enough that they're definitely out of copyright. That can be a useful resource. And feel free to give me a call. I'm always happy to do sort of an assessment of what you're doing in your business and give you the direction to make the right choices. So thank you so much for your time and attention today.
Thank you, Dineen.
Thank you so much. This morning has been so informative. I'm Vicki with KDC Outfitters, and we do a lot of, people have t-shirt ideas and they want to brand these. They don't know the difference between copywriting and how to protect themselves with their websites, models wearing their shirts and whatever. So you've answered a bazillion questions I had, and I can't thank you enough for coming here this morning and doing this.
My name's Scott Smith with We've Got Your Customers and Visibility Doctor. I've been building websites and doing online marketing for 10 years now. And one of the questions we have that comes up all the time is, can we use these images? Can we use these videos on the site? And how do we actually get permission in order to use these? Dineen is an absolute wealth of information, and I encourage anybody who has questions like that, whether you're a small business owner, doctor, dentist, whoever, who is hiring somebody to build the website, or even an agency, talk to Dineen. She'll be able to answer the questions. Thanks.
Anyway, Dineen, thank you so much. You didn't have a lot of legal mumbo jumbo. At least I understood that. So I was like really excited because obviously owning a magazine, I've got to make sure that everything that goes into the magazine is properly put in the magazine. So I so appreciate that. I also am so excited to get whatever you said you're sending me so that I can look at all of that stuff. So thank you so much. This was such an awesome, awesome, awesome experience. Oh, Mary Hervant Nash, The Advisor magazine.